Hello and welcome to Your Only Old Ones, an overview of estate planning. Today's session is presented by Corey Steady from Sheppard Mullin and Alison Gokal from Gokal Law Group. Before we get started, we want to mention a few logistical notes. In order to turn on live captioning, press the button with the CC symbol below. The session will be recorded and it will be uploaded to the LAAC website within 1 week of the event. And please feel free to use the Q&A or the chat to ask your questions. Thank you.
Well, was that it? Was that the intro? And now we should get started here, or should we wait for more folks to join?
It's up to you. We could go ahead and get started, and then I'll be adding some intro chat as well.
Okay. Perfect.
Go ahead.
Well, I'm Alison Gokal, and I do trust litigation. So I am not the estate planner. The wisdom of this is really Corey Steady. I'm just here to help guide you on how to stay out of trouble, which is telling you to listen to this guy right here. Go ahead, Corey.
Yeah. Hi, everyone. My name is Corey Steady. I practice in trust and estate planning and administration. And our connection here is actually that we've recently started doing clinics in Orange County that are intended to bring basic estate planning documents to those in the senior communities or those lower income communities. And so we are doing this presentation to a lot of senior facilities most recently. And so a lot of that is geared that way. And we've also tried to gear it towards everyone that may be on this call as well. Humbly, I think it applies to everyone. And as our colleague Brooke Weissman, who's on here, it seems, who should be giving this with us, would say is that as soon as you hit 18, right, you should have an advanced healthcare directive. So these are all important documents that, again, we think apply to everybody.
As we like to say, everybody dies. You can't take it with you. Even that massive collection of dad jokes I know you have, Corey.
That's right. We have plenty of cartoons in our office about that. Okay, so I think we're at 90. I think there were more signed up. So, at the risk of trying to draw this a little bit more, maybe give it another 30 seconds or so, and then we'll jump right into it. But I think what we can go to is as you do see the top, this is under the heading of the Elder Law and Disability Rights Center. And so that's the organization that we're partnering with, we're volunteering for to do these presentations in Orange County. One of our goals is to really reduce or eliminate conservatorships. And so we'll get into how we can do that with basic estate plan documents. And since this is falling under the heading of the Elder Law and Disability Rights Center, you get to see their vision, right? And how they work. And so that's what this slide is doing.
And a part of that is, and I think the biggest piece of the mission for this organization is to educate through you to the people you serve, to your families, and making sure you're in the know. I know many lawyers that actually really don't understand estate planning, that they don't understand the laws in the state of California, and they're lawyers. This is what they do, and yet haven't had that time to sit down with an estate planner to think through what happens to my stuff, what happens to my body, what happens to the people that are dependent upon me. And that's one of the big missions with ELDR, is to bring education and to stop the backup in the courts, to allow for the courts to do what they're best at doing, which is hopefully solving disputes.
Perfect. All right, we've hit 100, so I think we can jump right in. That seems like the century mark we can go with here. So that we've given a little preview of what the target of this presentation is, but really one of the targets here is that if everything goes well, you don't have to go to probate court, right? And if you do things correctly and you plan correctly, you never end up there. That's not to say you won't. And Alison can tell you that you could plan perfectly and you still might. But planning prevents or at least provides a pathway to avoid it. And so there's two scenarios that we're going to cover, right? How do you avoid it during your lifetime? And what documents do you do? And how do you avoid it at death? Because you can have issues both during life and, of course, at death with the court. And you can prepare documents that will apply both during life and at death. And so the lifetime documents that we're going to cover are advanced healthcare directives and powers of attorney. And the death documents, for lack of a better term, are going to be wills and trusts and other transfer on death documents, like a transfer on death deed, which would transfer real estate, or beneficiary designations on bank accounts or retirement accounts that would, of course, as they're aptly named, designate who would receive those things when you pass away.
So one of the big reasons why we want to avoid probate is, and dealing with it is, as you all know, the courts are very they take a lot of time and they take a lot of money. And what happens is if someone is alive, but they lack the capacity or they don't have the ability to make decisions, the question then is you have to go march into court and figure out who has the authority to make those decisions. The same thing with all of your assets. After you die, you're the owner and now you're dead. Who owns that? Who gets to transfer these things? And that's why putting in and being very open and honest about the fact that we all go into the grave. It's going to be whether or not we're kicking and screaming and fighting our way in, or we're just kind of throwing everything up to the wolves and letting our family members deal with the problems when we go.
And so one of the primary things you want to avoid during life, and Alison, maybe I'll kick it over to you to talk a little bit about conservatorship and the process and the difficulty in doing that, is a conservatorship. And that's what's needed if you don't have people in place to act for you while you're alive, but you have some level of incapacity. And so, Alison, can I kick it over to you for this?
Sure. So one of the biggest public things that have happened in the world of conservatorships is Britney Spears. And that became a very public display of when someone has power over another that maybe they shouldn't have that power, or maybe they should. The courts, especially in California, take conservatorship very, very seriously. The conservatorship time frame, where the court is blessing and saying that someone no longer has the ability to make decisions for themselves, to be able to make basic daily decisions, to choose where they live, to choose which doctors to go to even be able to get married, to do very simple things. The court has to come in and say, this person lacks that capacity. But in order to do so, you have to understand the nuances of the court documents. You're going to have to hire a lawyer. It's going to cost tens of thousands of dollars for an uncontested conservatorship. And that's just for something that everybody agrees needs to be done. It still costs tens of thousands of dollars. So the point of avoiding conservatorship is today, at this moment in time, to put the powers of attorney in place, to give people the ability to make the decisions for you so that when and if we lose that capacity, we lose the ability to think properly, that there's systems in place to prevent this very long. And I've seen conservatorships that have blown up to the point where family members are litigating for years and years. And in the end, there's no money. And in the end, nobody's happy. So, and it's all because someone didn't take the proper steps at the beginning to put a simple power of attorney in place.
And I'm a stats guy sometimes. And so the last stat I found was in 21-22, in Orange County, there were 594 conservatorships filings in just 1 year. So if we're looking at 600 a year in just one county, That's obviously more than one a day that's getting filed. And so it's a lot. And one of our goals and purposes of the clinic we're doing in this presentation, of course, is to minimize that number of conservatorship filings. And so how do we do that? Remember, we showed what are the lifetime documents. The first one we'll cover is the Advanced Healthcare Directive. And simply put, the Advanced Healthcare Directive is naming someone to make healthcare decisions for you when you're not able to do so. And it allows you to name an agent and successor agents to make those decisions for you. It allows you to provide direction on your end-of-life care, your end-of-life decision-making. You can provide very specific instructions if you have religious beliefs or of certain needs or requirements that you feel are important. Or it can be very broad, right, and allow the agent to make those decisions for you. This is a document where you can also include organ donation, and your healthcare agent is going to have a lot of authority over your healthcare decisions. Of course, while you have capacity, your healthcare agent isn't going to be making decisions for you. You will be making the decisions. There's an option in the form we use to make it effective immediately. And we often and generally always recommend that you do make it effective immediately, simply for the reason that if your agent has to prove you don't have capacity, you run into a little of a chicken and an egg issue in that your agent is going to have to get medical records to prove incapacity if it's not perfectly obvious. But if they're not your agent yet, they're not going to be able to access those medical records in order to show that you don't have capacity. So it really comes down to finding a person that you have a significant amount of trust in that will make the right healthcare decisions for you. And you can provide detailed instructions if you so wish that will direct them. The last point we'll make on your healthcare directive are that you should make sure that the people you name are aware that they're named in the document so that they're willing to act and that they know they need to act. We also recommend that your healthcare directive be on file if you have a primary care doctor. I see a question that just came in. Have I filled one out with Kaiser? You probably have, right? Most hospitals will have a form that you can use to provide those directions and name an agent. And it may not be bare bones. It may be perfectly sufficient. And it may work well to use the Kaiser form if that's the hospital that you're using. And then the last one is that in the form we use, there's little wallet cards. And so I always recommend that you throw those in your wallet because with a lot of these documents, they're only as good as the fact that people know they exist and that you use them and provide them to people. And so if you were in an accident out in the street somewhere, a primary or, a first responder is not going to know you have a healthcare directive or know who to call unless you happen to have one maybe in your wallet. So, we're trying to cover a lot of bases here with those last comments. But again, the healthcare directive is really primarily going to name people to make healthcare decisions for you.
And one of the key things that people always ask me is, can you switch? Yes, of course you can switch. You can change your healthcare directive. Maybe you name your spouse and I don't have my spouse as my healthcare directive or have that power because I think that he either may want to pull the plug too soon or not be able to make that decision. So I put my sister in charge of it because she will pull the plug when it's necessary. So you can make those changes because as you age, and hopefully we all go to a very, very ripe old age in the 3 digits, people in our lives are going to change. Our spouses, our children now have the ability and the power. And so you can make those changes, but as long as you are open and honest and you share this information with the people that are the power of attorney or will be the power of attorney or are no longer the power of attorney, you will save a lot of stress and save a lot of stress for the hospital or the medical providers because you want them not worried about who's making the decision. You want your medical providers worrying about you and your health. A lot of insurance companies actually have into their portal, you can upload now your power of attorney. It's now on a lot of your iPhone. You'll have your emergency contact information. You can throw that on there. There's tools now with technology that enable us to incorporate these powers that are very simple but incredibly important.
The next one we're going to cover is a power of attorney for assets. And similarly, this names an agent that is allowed to or afforded the powers to act over your assets and to take actions for you as if they were you, right? Given the powers pursuant to the power of attorney. They're your agent and they have fiduciary duties to act for you. Of course, we can't prevent people from doing bad things, but at the same time, you should make sure that you name somebody that you trust. And again, they have fiduciary duties, so they are obligated to do the things for your benefit and act for you as your agent. A few terms of art that apply to these powers of attorney, and then a few of the powers to show how broad and far-reaching they can be. The power of attorney is revocable, so you can change it, like Alison mentioned with the healthcare directive. You can always change who's in charge. You can always revoke the prior power of attorney as long as you have capacity. And capacity is important because you often hear it called a durable power of attorney. And the term durable means that the power of attorney lasts beyond your incapacity. So we often recommend you make it effective today so that the power of attorney, your agent, doesn't have to prove up anything, right? And so if you did that, the power of attorney would be effective now, and it would be durable and have the appropriate language so that upon my later incapacity, my agent still couldn't act for me. So it lasts now all the way through my incapacity. Just like the healthcare directive, this power of attorney form, it only lasts during your lifetime. So as soon as you pass away, the power of attorney or agent's power are no longer effective. And I mentioned effectiveness and when you make it effective. So there's the ability to make it effective now when I sign it. But let's say, for example, you wanted to make it effective later. It could be at a certain date. It could be upon incapacity. There's various reasons why you might want to consider all these things. It could even be something so silly as, on the days that I wear a blue shirt, right? I mean, it could be such a wide range. Our general approach is to try and make it effective immediately so your agent doesn't have to prove up that the item springing that agent's power into authority is true, so that they don't have any delay in action should you need action. But of course, you have that option when you're doing this document. And then lastly, just in terms of how broad reaching the powers can be, your agent could sell your home. Your agent could file your taxes. Your agent could withdraw all the money from your bank account. Sounds a little scary, but when you think about it, these are powers that you want someone to have if you don't have capacity so that they can continue to take care of you, right? These are things that these are documents you're putting in place now so that your agent can keep you in a home, can keep paying your bills, can keep paying for your care in the event that you're not able to do so.
And I think one thing that bears repeating that Corey just stated is that the power of attorney works while you're alive. The moment you pass, you've got to move into other planning documents. So the power of attorney is stepping into your shoes. If you have the power to do something, so you have the power to make choices while you're alive, your agent, the person who you've put in place as that power of attorney, has that same power. But once you pass, you've got to start looking at other documents, which is why all of these things are building blocks to our eventual demise. Corey, take us away.
Yes, we're getting there. We're proceeding throughout our lifetime here, and we've reached things that we're going to cover under estate planning, and then the relationship with Medi-Cal and Medi-Cal reimbursement, because there is a lot of overlap between the two. And we're not going to spend a ton of time on Medi-Cal today, but the key point, right, that we want to raise is that there are Medi-Cal benefits now that they're solely based on income. So more people are going to qualify for Medi-Cal than before, right? Before it was an asset-based test, and now it is just an income-based test. Specifically, there's age and disability requirements. And in fact, I bet some of you on this call likely know more about that than I do. And so the piece, though, is that if you use Medi-Cal benefits and you pass away and your assets go through probate, the government can come seek reimbursement for the funds that they paid out for your care. And so that is a key thing, because there's very simple things you can do to avoid that. And so we're going to go into all of those, but that's the connection between estate planning and Medi-Cal and its care. So the two documents we're going to cover are what happens to your assets at death, are wills and trusts. So a will used to be the most important document. It's now used less commonly than a revocable trust for most people in California, but that doesn't mean everyone needs a revocable living trust. So the will identifies who's going to get your assets when you pass away. Simple as that. The will also identify who's in charge. It's the executor. And the will, lastly, and maybe of most importance for those with minor children, it will nominate guardians for your children, and we'll get into children on the next slide as well. But that's where you do it. You do it in the will. The downside with the will, and again, we'll cover more as we get into specific examples, are that in order for the will to become in effect or powerful, you have to go to court, and the court has to admit the will, and the court has to provide the power to your executor. And so that is a probate process that is, again, back to our time-consuming, potentially expensive, and you can avoid that if you would like to avoid that. Then we'll go into, well, Alison, anything you want to add on wills before I jump over to trusts?
No, because I think it ties to the trust. So yeah.
So then a revocable living trust is a commonly used tool in California and in most estate plans these days. And that is the use of a trust to put your assets into the trust. And you use that to serve as your vehicle, both during your lifetime and at your death. And so often you use a trust if you have assets that exceed a total value of $186,000, which is, we'll get into, a arbitrary number that you can transfer without going to probate, or alternatively, if you own real estate, because the real estate number is only 60,000 plus or minus. And most people that own any real estate, it will easily exceed that small number, especially here in California. Benefit of a trust is that you don't have to go through the probate court process. The trust acts as its own mechanism to transfer your assets. And in the trust, it would say who's in charge, which is the trustee, and it would say who gets what and when. And so the document would cover all of those items. And Alison, I'll kick it over to you, I think, because I think you have a nice way to outline how trusts work here, if you'd like.
Okay, so I didn't plan very well, but so when you think about the bigger picture, which is when you die, there's no one there telling where your stuff goes. You own it. So somebody has to take ownership of it and direct it where that asset or that property should go. The probate court only steps in when you've got that 184, it changes every year with inflation, but when you've got that $184,000 mark. The property in California is what Corey's saying is that it's much higher, and it's not about what equity you have in the property. It's the value of the property. So your value is what you need to, or how much that property is worth. So what happens is when you have a trust, you create a document, you create something, and you throw all your assets in it. So those are my vitamins that I was supposed to have taken over the last week that I didn't. So I'm throwing them all into the trust. When you die, it's locked. And then the person that owns it, or the entity that owns it, the creation, is the trust that owns it. So now the trust has the authority to now disperse and distribute your assets as you want. Otherwise, you just have vitamins all over the place, and the court has to pick up those pieces and figure out who owns what, and it's costly and it's super expensive. California law is geared for California. If you're trying to deal with assets in Arizona or in Texas or family property in Lake Michigan or something like that, that's That's not what we're talking about. We're talking about California and California property and assets. And you have to go through the steps that the state of California enables you to do, which is creating this revocable trust. And it helps save on taxes. It helps save on confusion. And it makes sure that you, the person that earned all these assets, the person that did all the hard work, get to decide where things go.
And so admittedly, revocable trusts are very common and are used very often in my practice and almost exclusively used in my practice. But I think it does bear repeating that you may not need a trust. And we'll get into some examples, right? Where depending on your assets and depending on your family situation, right? You may not need it. And I see a question about planning for real estate. And I think when we get into some later examples, I think we'll be able to cover those nicely with some specifics. But you may be able to find ways to transfer your assets and plan for them without a trust. You know, the benefit of a trust, I think, is important, humbly, but you may not need it, and you may not need to incur the expense of doing so, because you can do a will, you can do a power of attorney, you can do a healthcare directive, probably on your own or in a clinic setting. We feel we can do them with people. When you do a trust, right, our recommendation is always that you work with legal counsel to do so, just because there is some complexity and it warrants, you know, the few $1,000s that it will cost, because it's not cost-free to do the planning with the revocable trust.
And just to Lisa's question on the chat, I think is great, is the do-it-yourself estate planning and adding kids as joint tenancies. We will address that, but sometimes when you do it yourself, there are unintended consequences. And so you really have to think through and understand what the laws are, because when you start trying to fix things when there's already a solution there that works with the law, and you're trying to get around doing that, sometimes you create more problems than you intended to avoid. So, but it's a great question. So we'll dig deeper into that one in a few slides.
Yeah. Okay. So the next slide, so we talked about what you can do in your will, and specifically in your will, you can name guardians of your minor children. And so I think this slide, Alison, you'll cover just some brief points about what happens to your children if you pass away while they're in their minority or while they're minors.
Yes, and so I have 3 kids. Corey's got 2 kids. We think about death all the time, and we think about our children. And part of it is who's going to be responsible for them. When you have biological children, adopted children, you're legally their guardian. So you're legally picking under your will, or you can do it through a trust as well, kind of distribution of your children and the assets. You get to choose where your kids go. You need to choose where your children go, and that changes. And you're going to change that over the course of your children's lifetime. My kids were going to go to family in Texas, and now they're going to be with friends in California. And that's just things that we do as our children age, because it's what's in their best interest. Foster children are a little bit different, and it's a little more complicated, as some of you are very well aware. The foster system is that way. A foster parent doesn't have that legal rights that a guardian does, or an adopted parent and biological parent does. So the court has to actually, the foster care system is going to have to actually look into and analyze what's in the best interest of the child. Is there, if one parent passes or one foster parent passes, is there another qualified foster parent or foster adult in that household to be able to step in and take care of that child? Does that foster child need to be moved to another home? The social work system around foster care is geared, it's supposed to be geared towards the best interest of that child. And so it's taking into account searching for next of kin, looking for potential for adoption or other alternatives to foster placement. And then the foster care system also should be providing it, and is available to provide counseling services and support to that foster child due to this, sudden death or loss there.
And I would just add some color on naming guardians in the will. And so you get to nominate the guardian as to who's going to do it. The process, though, is whoever you nominate will have primary authority to go to court and petition to become the guardian of the child. But the person who you name still has to go to court, get approved by the court in order to do it. So it's not an automatic process. It still is a court process, just to add a little bit of color. So it unfortunately does involve the court, in the court making the decision as to who would be the guardian of your children, even if you've named that person in your will.
Okay. And then one question that just popped up on the questions was asking for the difference between revocable and irrevocable trust, and in what situations do you recommend the other? Corey, I can answer that, but I'd rather hear your answer. It's going to be better.
Yeah. Well, so just to jump back, right? You want a revocable trust during your lifetime, right? And your basic estate planning is it's going to be a revocable trust because they're your assets, they're under your control. And while you're living, you have the ability to revoke or amend the trust. That's the general planning and mechanism that you use a revocable trust for. The trust, again, is revocable during your lifetime. It becomes irrevocable at your passing or at the passing of the second spouse, right? If there's a married couple that creates the trust. So in Alison's example, she threw the cap on the jar, right? That was kind of the transition from it's revocable, I have capacity, I can change it, to I've created a trust, I've passed away, and now it's irrevocable, right? No one can change it because I was the only one with the authority to amend or revoke. Now it is irrevocable after my passing. So that is the process, or that is the general process that we see in basic revocable trust planning. You can separately create an irrevocable trust during your lifetime, but that's going to be more complex gifting and planning purposes, probably outside the scope of what we're covering today. More in the scope of what we're covering is it's revocable during your lifetime. It becomes irrevocable after your passing.
And then just we're going to jump back quickly to guardianship because it sort of is related to children in some ways. So someone asked if you can fight guardianship. For example, the aunt is named in a will and wants guardianship, but another aunt wants to fight it for some reason. Yes, you can always go to court and fight things. What's going to end up happening is this balancing test that the court is doing. What's in the best interest of the child? What did the decedent want? Was the decedent subject to undue influence? Was the one aunt manipulating? What the court will do in these types of situations is they'll try to push people to mediate as much as possible, but it's the parent's right to choose that guardian. And if the parent was doing that properly and there's no risk to the child, then the court's going to oftentimes try to side with the decedent, the parent that made those choices. There could be other reasons, but in those types of situations, it's coming to a resolution as much as possible and mediating those, trying to come up with solutions of joint custody or sharing or having that support system around the child instead of creating these battles. Because yes, it's always possible to fight, but whether or not it's in the best interest is a whole other question.
Great. So then what we're going to move on to next are some specific examples of planning for assets and liabilities, and how those things can be planned for at death, right? We've talked about the lifetime documents, which are the healthcare directive and the power of attorney for assets. And we've talked just most recently about wills and trusts, which are going to make plans for when you pass away, both for your children and your assets, and who's in charge of those. And so now we're going to kind of just go into some specific examples of those various items and planning techniques and ideas for those things. So the first thing we'll cover are things that may be near and dear to many people's hearts here, are debts, right? These are obligations that you owe somebody, a bank, the federal government, whomever it may be. And so briefly, we'll just go through what happens to these things at a high level when you pass away. And so difference in student loans is you could either have federal loans, and there's a couple different types, or private loans. Generally, federal loans will be discharged upon death, and it would require a filing with the agency or whomever is holding you, servicing your debts, generally. And then the opposite side of things, generally, private loans are not discharged. There are some private loans that can be, and it's all pursuant to the terms of the loan agreement. And so private, it's a very lawyerly, it depends answer. Federal, generally, these are going to be discharged. And so what happens if they're not discharged? So for example, credit cards, medical bills, other debts, those become liabilities of your estate, right? So your assets are obligated to pay those things. Your creditors have to come and actually file in court a creditor's claim. So there's a process for them to try and claim their fees or whatever it is that they're due. Or unless whoever is in charge of your estate agrees to just pay them. But there's a process the creditor has to follow, and they have 1 year to come and get their debts paid. And so often we'll see sometimes that they're outside of the 1 year statute, right? A credit card bill, for example, they don't come to collect it until a year and a day. You can object to that, and you can push back and say, no, you didn't do it timely. And that is up to your executor, which again is the term of art for who's in charge under your will on behalf of your estate. And so with regard to the debt process, if that's going to happen, it is a probate proceeding. And so you will be stuck in court potentially for those things, unless, of course, you recognize or you have a revocable trust that those are real debts, right? Like you had final medical bills and your family is going to pay them, right? You don't have to go through the court proceeding for that. It would be for other things that happen later or things that you would want to object to potentially. So that's kind of a brief touch on what happens to debts when you pass away. Alison, anything to add?
Yeah, I think part of that too is that Medi-Cal recovery where your estate owes money to somebody, because even if you aren't still around, your debt still sometimes can follow you into the grave. But the one takeaway that everybody should celebrate is federal student loans. Yeah, I finally killed them if I'm dead, but you're dead, so I guess you can't really celebrate that much.
That's right. That's right. And so the question I see on the chat right now, or on one of them, is, do you have to provide notice of death, or is recording the death enough? Right. So if you're going to do a probate proceeding, there are notices to creditors that can go out, and there's a notice to creditor procedure. Even if you're not doing a probate, there is also another notice to creditor procedure that you can follow for trust law. There's the trust one is not mandatory. The estate proceeding one is mandatory. So that is the case. You then also often, most cases, mortuaries or those things will notify Social Security. And so with regard to if you're getting Social Security, they'll automatically take it out of the accounts. The government has pretty strong reach when it comes to that. Alison, anything to add?
No, but somebody else had a question about the Parent Plus loans. I know it's really sick, but yay, if your student dies or if you die, they can be discharged. So again, it's falling in line with what the rules of the contract are, which is federal loans. Most 99.9% of the time, those are going to be discharged upon death, because that's what the federal government allows. Whereas the private loans, it's really specific to what the terms are stating. And that's the student loans usually are discharged because most of the time people are taking it when they're much younger, and then they're paying for it until they have all gray hair. Or maybe I'm just speaking of personal experience. We'll get there one day. So at death.
Perfect. So then, like we mentioned, we would come back to this. What we're going to do, planning for assets, and specifically this one is planning for real estate. what do I do, and how can I transfer real estate in an effective way, and in a way that doesn't cause problems. So we'll also cover adding kids and adding joint tenancy, but we're going to go through this slide first. So there's probate transfers and non-probate transfers. If we haven't drilled this enough, a probate transfer is something that has to go through court, and specifically through the probate court, in order to effectuate the transfer. A non-probate transfer means I'm not going to court to transfer this asset, simply put, right? And so we've split them into two examples. So you'll end up transferring your real estate through a court probate proceeding if you do nothing, you have no plan, and in fact, your assets, if you have no plan, will pass pursuant to what's called intestacy, and that's under the California Probate Code. It sets forth what happens to your assets if you do nothing. And it simply goes to your spouse and children, and then to your parents, and then to your siblings, and then to more distant relatives if you do nothing. Then if you do a will, you also have to go through the probate proceeding in order to transfer assets. So if I just had a will and I had a house and I said, my house goes to Allison, she would have to go to court in order to get that house transferred to her if it was only transferred to her pursuant to my will. So those are probate transfers. We have the third bullet point, which is pretty key here. Anything I transfer through probate is going to be subject to Medi-Cal reimbursement. So if I utilized Medi-Cal services in my older age, and I had a home or a piece of real estate, and I transferred it via will or no estate plan documents, I would have to go into probate. Well, excuse me, I would be dead, but someone would have to go into probate, plan to transfer the asset. California would come in and say, you owe me X dollars as reimbursement for my Medi-Cal costs that I paid for Corey. The problem there is that if it's just a home and not significant other assets, it may require the sale of the home in order to reimburse the government for those Medi-Cal expenses that were expended. That is a big problem and something that's a big focus, because it doesn't have to be that way, right? We're going to get over to this other box, but it causes a lot of problems because homes are one of the ways to transfer generational wealth. And if you're transferring your home through probate and you're having to sell it in order to satisfy Medi-Cal reimbursement, you're losing that generational asset and you're reducing the value of that generational asset. Because if we just jump over to the right side of the slide, if I did a revocable living trust or a transfer on death deed, which we'll get into, there's no Medi-Cal reimbursement on those transfers. Just to be clear, it doesn't make a whole lot of sense. But if I do a trust and put my property into a revocable living trust, and the trust says it goes to Allison, she doesn't have to go to probate. She doesn't have to, she's not subject to any Medi-Cal reimbursement on that. The transfer on death deed is a specific type of deed that says, I'm the owner, and this is who it goes to at my death. That's actually recorded with the county. So both of those methods avoid Medi-Cal reimbursement.
The one thing to think about is, yes, we're sort of stealing from Peter to pay Paul in some ways too, is that you're not going to get that Medi-Cal reimbursement, but there are sometimes tax consequences when you transfer an asset during your lifetime into a joint tenancy, because then you have this whole concept of step up in basis. What's the tax consequences for the capital gains when you sell the property, or what are the tax consequences for property taxes? Is there a reassessment? So there are tools that are outside of trust that are highly beneficial, and one is that joint tenancy with the children. But when you hand over a joint tenancy to your child, let's say I own my house and I hand over a joint tenancy with one of my kids on the house. What that child can do is that child can now split and break that joint tenancy. And now she owns 50% of my house without my buy-in on it too. So there's consequences when you bring in joint tenancy, because in essence, you're saying, yes, when I die, it jumps to them fully. And that's an immediate death transfer. But during my lifetime, I may not have control of things. So it's about trust and understanding the consequences. If one person decides to act naughty, what the risks are to you as well.
Yeah, and that's the exact answer I would have given as well. And you can avoid that, right, by keeping control over the home through a revocable trust during your lifetime, right? You don't give up any control of the property. And second, one of the key items is that you're not going to run into any property tax reassessment issues, right? And so there's a new Prop 19 passed in 2021. And so there's a really limited parent-child exclusion now as compared to before. The prior laws, you could transfer an entire residence without causing reassessment to your child. Plus, you could transfer another $1 million of property to a child with no reassessment. Now, it has to be your principal residence, it has to be the child's principal residence, and it only shields up to $1 million of value increase. So that may be okay, and it may cover some of this, but you really want to consider that, because the annual property tax can be significant if it's changed and done by mistake. We had someone that worked in our office. He transferred property to his mom and didn't realize it was going to cause reassessment. And we had to go in and try and rescind that deed, which was a pretty complicated process, and is still in the process of trying to see if the county is going to agree to not cause that reassessment. So those are the issues that I think you're going to want to focus on when you're doing the DIY and adding someone to the property. Is you lose control and you have potential tax consequences. Property tax probably being the biggest. Of course, is a gift, but everyone has a giant gift exclusion now, so it's probably not triggering a whole lot of issue on that front.
Yeah, but again, I mean, it's the step up in basis, it's the changing of those, and there's consequences to it. Ruby, I know you asked about bank beneficiaries. We're going to touch on that in the next bit, but Jonathan asked, is Medi-Cal health insurance, not the long-term care, also subject to reimbursement? My understanding is that Medi-Cal is, if you qualify, then anything that passes through probate is subject to Medi-Cal reimbursement. That's the whole point of the new law, because now it's income based. So if you're not earning the income, but suddenly you get this massive inheritance, and then when you pass, you have to distribute those assets, and you're not doing it via trust, you're going through the probate court, Medi-Cal is going to be asking for some money back.
Yep. So leads right into the next question, which is, how do you plan for bank accounts and investment accounts? So again, same setup here. On my left, we have probate transfers, and on my right, we have non-probate transfers. So same examples. If you have no plan or a will, and it depends, right? You potentially have to go through probate court, and it's subject to Medi-Cal reimbursement. If you have a will on the it depends spectrum, or a revocable living trust, or beneficiary designations, payable on death, transfer on death, or named beneficiaries, you don't go through probate court. Those happen automatically. So the beneficiaries named are actually contractually agreed upon with the bank, and so they transfer automatically through the bank, and not subject to probate court, not subject to Medi-Cal reimbursement. So the it depends item is on the will, and so there's a small estate number. It's right about $180,000. We'll use that round number. I think it's 186 now, whatever it is. It changes for inflation. If you have assets that are lower than that, right? So let's say your bank account, your only asset was a $120,000 bank account, and your will says, I give it to Johnny. Johnny can go to the bank and collect that bank account, if that's your only asset, because it's under $180,000, with what's called a small estate affidavit. And that small estate affidavit is Johnny saying to the bank, I am the successor in interest. I am signing this under penalty of perjury. The decedent's assets don't exceed $180,000. And the bank will rely on that form, that small estate affidavit, to transfer those funds to Johnny. So that's why it says it depends, right? It depends on the value of your bank accounts and your other assets. So it's bank accounts. Let's say you had a $120,000 bank account. and a home that were both in your individual names, you're stuck in probate because it's your combined value of your estate assets. Now, if you had just a bank account and a home that was in a trust, your small $120,000 bank account could still pass via small estate affidavit. And so
it's important to think about, there's a couple of different things. Some people put family members jointly on the bank accounts. Some people do a pay on death beneficiary. Sometimes annuities, 401k, Roth IRAs, they usually have pay on death beneficiaries. But when you put someone on a joint bank account as a joint signer, and sometimes people do that for, it's a term of art in court, convenience sake, that's done for convenience. There are consequences if that person is doing bad things, if they're not using those assets properly. But sometimes if you're putting them on a bank account and they drain that entire account, it's a consequence of doing that, and sometimes that money is lost. So when you look at the pay on death beneficiaries and who you're putting on the accounts, one of the things I recommend is making sure you know every single person that's the pay on death beneficiary for which account, having a spreadsheet, going through it and reviewing it once a year to make sure that you have the right key people in place to protect you, because as we know, sometimes people can be very naughty.
That's right. And then if we have the small estate affidavit, there's a form under the probate code, which is 13100. That's the probate code section. But banks will often have their own form. Usually it'll add an indemnification on there, and what I've noticed, just so they protect themselves. But in that instance, it's probably not something you're so concerned about, right? If you truly are the right successor in interest signing that form. Then the other question that I see, we'll cover the 401k on the next slide. If you have two different bank accounts, the legal technical answer is that your assets, your total estate assets, would exceed the amount that are subject to the small estate affidavit. That's not to say I've never seen in my lifetime someone try and do that, but we cannot legally suggest that that would be an appropriate thing to do.
Yep. Again, it's always, I know we're trying to figure out ways to game the system. There are ways to do it, but sometimes when we try to game it, we end up creating more problems. That's my 2 cents.
Yep. So the other thing we'll just touch on, which is more modern too, is electronic and personal items. Again, you can run through a probate or a non-probate transfers on these. These are as simple as, your doll collection all the way up to your Facebook, right? And who has control or who gets these things. Again, it's no plan or will. You may have to go through probate to transfer these assets. If you have a will or irrevocable living trust, you will not have to go through probate. Most often we see with personal effects, our trust document says, split amongst the children as they agree. And then it's up to the kids to equally divide the assets, but they don't have to go through probate to do that. They're able to do so pursuant to the trust document. The electronic assets, there's kind of more current law on that in the code sections that apply to those electronic assets, but often we'll name somebody with authority to access your electronic assets and, get your passwords, do all these things so that they can access them, shut them down, access online records, all these things. So they're important to think about when you're doing these planning documents, and so that you can name someone that has authority to do this. And if you don't name someone that has authority, then you may have to go to court to get somebody with the authority to do so. And then last but not least, as requested, 401ks, retirement accounts, life insurance, all pass by beneficiary designation. And so you will need to, and this is a good health checkup reminder, check who your beneficiary designations are on your retirement accounts or your life insurance. It may be different today than it may have been different when you signed it initially, when you first took that job, if they offered life insurance or retirement account, than it is today. And so it's important to make sure they reflect who the appropriate parties are. There's the question is who, well, and let's just say, if there's no designation, it's going to, in all likelihood, well, it will follow the terms of the agreement by the custodian. And in most cases, if there's no beneficiary named, it's payable to the decedent's estate. And that then requires a probate, depending on the value of those assets. And then sucks you back into probate court if you don't name beneficiaries.
This is probably one of the most common and silliest case pattern that I have in my office, which is someone has a life insurance or retirement account that names an old trust, a trust that you did when you were married to your first spouse, or has the first spouse's name listed, but as you're working, you're earning community property into that 401k pension. So there's community property rights for your current spouse. And so this is an area that is the reason why I have a business sometimes, because there's always problems with it. That's why, again, why I say check every year. Your life changes. Life changes fast. Kids change, spouses change, who you like and who you don't like changes. I would check this once a year. I would suggest your paid beneficiary is an individual. It's a lot easier. Some people put it into their trust's name, but sometimes that causes problem if they change their trust and they're like, oh, that's titled in my 2022 trust, and I changed my trust in 2025. And the trust name is changed. I gotta go into probate court. And again, tens of thousands of dollars to do that, because you have to give everyone possible notice. You've got to deal with the banks. So it's really important to constantly, every year, maybe on your birthday. I mean, what a great birthday gift to yourself. I'm going to die. I should enjoy this year. And now I'm going to go through all of my estates, like the same time you schedule your mammogram or your colonoscopy. It's every year, man.
Yeah, no, that's great. And under the Secure Act, most of the deferral that used to exist has been taken away, right? So you only have a 10-year deferral if you're a non-spouse beneficiary or a non-minor or a non-disabled beneficiary. So you can only defer, the benefit of a retirement account is to defer the taxes and let it grow tax-free. And so you only have 10 years, again, if you're a non-spouse, non-minor, non-disabled beneficiary. And if you name a trust, unless you make clear in the trust that it qualifies for that 10-year deferral, you're likely subject to only a 5-year deferral. So it's not a significant difference now. It used to be pretty significant because it could have been the lifetime of your children. They could have deferred it. Now it's limited to only 10 years. So it's a little bit less of a difference. And the considerations I would have is, what age are my children, right? I name my spouse, but do I want my minor children as beneficiaries? Can they even be beneficiaries, right? So it's going to be things to think about when you're doing it. And the last question I see here is, do I have to be a resident or a citizen to be a beneficiary of a retirement account? I am not 100% certain on that answer, but what I would say, though, is that the problem you're going to run into is that person's home country rules, because the US may not have an issue with it, and you may have to do certain withholding, and you probably likely have some pretty significant withholding requirements, but it's also going to be a different issue in the foreign person's home country. So Alison, I don't know if you have a better answer.
So I've dealt with this before. There have been some pretty significant challenges to do that on both sides, because yes, you've got money going into another country. And if for some reason that country is not recognized by the US and Congress, there's problems there. But the other thing too is a lot of the banks want to have a social security number for the transfer, because they're doing that for their tax reporting purposes so that they can issue either a K-1 or whatever documents are necessary for taxes. And when there is no social security number, it becomes problematic. Sometimes then you use that tool of pouring things into the trust, and then the trust pours out. But again, you run into tax consequences or the distribution consequences. So these are really good questions. There's easier ways to get in a country into, let's say Canada or Mexico, because there's a lot, because we share borders, there's a lot of reciprocity between Canada and Mexico for those types of distributions. But when you get into countries where our bank doesn't necessarily, or the bank where the 401k is sitting or the pension plan is sitting, doesn't have a connection to a bank in that country, it becomes really problematic. Croatia is not a fun country to deal with on that type of issue, just FYI. So.
All right. Well, and I think we've taken a lot of questions throughout, and we really appreciate all the questions. But we also appreciate everyone listening in. I mean, Alison, anything to conclude with?
No. So Gabriella asks a really good question about if you're making changes to the trust document for your guardian, making those switches. I'm going to tell you this, and the law is probably going to switch in a couple of years, but current case law says you have to look at the terms of what your trust allows you to do and make those amendments and changes, or what the probate court allows, or what the probate code allows you to do. So if you're making changes to your trust, changing distribution schemes, changing who the guardian is, you have to really follow to the T, the rules or the requirements that are in your trust for those changes. It's possible to do it yourself. It's also possible that I know lawyers that have tried to do it themselves, and I looked at it and it wasn't done properly. So if you are going to an attorney to create that revocable trust and putting that process in place, talk to that lawyer to make sure that the terms allowing you to amend your trust, one, protect you from anyone faking it, and two, give you the ease and means to do it very clearly. But again, lawyers always say it depends, because it always depends on what the California Supreme Court and the appellate courts are going to come down with.
Great. Well, thanks again, everyone.
Perfect. All right, now everybody can go live their day, enjoy their life to their fullest, and be prepared to die when it's time.
Oh, perfect.
Thank you for joining us for today's webinar. This webinar was hosted by the Legal Aid Association of California, also known as LAAC. We are the membership organization for California's civil legal aid nonprofits. Our job is to advocate in the legislature, in the courts, and with the State Bar of California on behalf of the community of nonprofits that serve low-income Californians. In addition to our online and in-person trainings, LAAC provides coordination and advocacy for increased funding to support organizations like yours. Thank you.